Hello, everyone. Welcome to the final installment of the 2023-2024 Resident Member Series at Green College. I'd like to begin by acknowledging that UBC Green College is situated on the traditional, ancestral, and unceded territory of the Musqueam people. For those that are new to the Members Series, it is a weekly public lecture series in which resident members of UBC's Green College, graduate students and postdoctoral fellows, present on topics related to their research or field of study or interest. Today's speaker is Zachary, or Zac Couture, who is a law student and activist from Amiskwacy Waskaigan, otherwise known as Edmonton, Alberta. Through legal advocacy, creative theory, and education, Zac hopes to advance solidarity work as well as anti-racist and decolonial frameworks. Zac is currently conducting research and editing in support of a consultancy report to the International Labour Organization on migrant worker access to justice. He is also working with Edelman Law, a leading refugee and, quote, crimmigration firm, to research bias in findings of criminal inadmissibility of migrants to Canada. So please join me in welcoming Zac.
Right. Thanks, Michael, and thank you for all of you for being here. All of you are friends of mine, people who also live here with me, so you all know my name, but I will say it nonetheless. My name is Zac Couture. I'm a law student at UBC and a current resident here at Green College. So before we begin, it is important to acknowledge that we are gathered here today on the traditional, ancestral, and unceded territory of the Musqueam Nation. The University of British Columbia, and by extension Green College, is situated on the lands and waters to which the Musqueam people are the rightful stewards and traditional stewards, and under a context of ongoing settler colonialism. In order to affirm anti-oppression and anti-racism anywhere, we must first address how we are complicit in the continuous colonial process here at UBC. I would like to ask that we recognize that decolonization is not simply a metaphor for social justice or general societal improvement, but that involves an actual material repatriation, a giving back of Indigenous land and Indigenous life. This acknowledgement serves merely as a first step in fulfilling our constant responsibility to Indigenous peoples and the lands that we organize on. It is also important, as we discuss the topic of legal justice in the context of international students, that we address the fact that I'm going to be speaking in a context and a framework of a colonial law, the Canadian state law. Oftentimes, when we talk about the rights of migrants and immigrants, the discussion and recognition of settler colonialism becomes absented. This is often under the premise that the rights and interests of immigrants and refugees must inherently be at odds and juxtaposed, opposite to those of Indigenous peoples. However, as we begin to imagine a more just world for all, we must confront injustice in all its forms. And this includes confronting the authority of the Canadian state and upholding unilateral control of immigration law without consultation, engagement, or even consideration of the authority of Indigenous peoples. A world that bridges the fundamental rights of migrants, refugees, and Indigenous peoples is attainable, but it must first begin with respect for the autonomy of Indigenous peoples. It may require creative and interdisciplinary thinking and solutions, but the first step is to discuss settler colonialism as a structure that exists in our immigration system today. And with that, I'm going to actually start. So, recent media and political discussion has centered on the topic of the housing crisis. And I think we're all very familiar with the housing crisis being here in Vancouver. I've never been so class conscious in a city before. I've worked out in the downtown east side, blocks away from some of the most expensive housing in the entire country, but situated where on public display there are folks who are houseless and who are denied their most basic and fundamental rights. And I think we're all aware of the cost of living has become exorbitantly high for a large number of people living in Canada, whether citizens or not, from Montreal to Victoria, from Mississauga to Richmond. A lot of recent media opinion discussion has centered specifically on international students and their role and how they're situated within the housing crisis. And I'm not sure if any of you have seen Who here has seen any kind of ads or news headings similar to this before? Yeah. So this has become a very topical thing of discussion to talk about international students, specifically in the context of housing, and specifically as a problem for housing. These headlines have cemented an impression across Canada that the presence of international students is contributory to the housing crisis. And so the international student as a person becomes abstracted. They are merely a foreign consumer who poses a dangerous economic threat to the everyday Canadian. Mark Miller, the current Minister of Immigration of Canada, has publicly stated that international students raise concern when it comes to Canada's housing. In his words, quote, "International study is an ecosystem in Canada that is very lucrative, and it's come with perverse effects as well. Some fraud in the system, some people taking advantage of what is seen as a backdoor entry into Canada, but also pressure in a number of areas. One of those is housing," end quote. But the idea of newcomers posing a threat to the Canadian housing market is actually not something new. It's not something that just happened in the last few years. So I'm going to just take you a little bit back in time to 1976, when Canada was enacting a new Immigration Act. And this was a time where they were deciding to modernize it, make it in line with more human rights instruments. They were finally going to get rid of, the provision that no homosexuals or idiots should come into Canada. So this is when Canada was going to start a new modern immigration system. And in the context of the debate, submissions made to Parliament noted a numerous hostile accounts of immigrants, quote, exacerbating housing shortages and taxing welfare rolls. The mayor of Vancouver at the time submitted a report that said immigration has exerted great pressure on land and therefore on housing prices. He said this is primarily a spatial question, not a racial question. And this is a common theme from then to today that we continuously see in talking about international students, migrants, newcomers, foreigners, and housing. This is presented as a debate that's merely factual, that's racially neutral, and that it's not really about who's unbelonging in the Canadian community. It's merely about the functioning of our welfare system. It's merely about the functioning of our housing. And so, but the fact is, who is it that is being singled out in this discussion? Who is it that is being the primary focus and subject of scrutiny in this debate? So Prime Minister Trudeau had recently made a public declaration that international students should not be singled out as a cause of the housing crisis. And he recognized in that public statement that there are multiple factors at play that contribute to unaffordable housing. But he only made this statement after a policy was enacted by Parliament capping the total number of study permits allowed into Canada. This statement was only made after policy was made that singled out international students. Next slide. So let's talk about this. Let's talk about Canada's response to the housing crisis in terms of how they were regarding international students. So as of January 2024, the Department of Immigration, Refugees and Citizenship Canada announced that it would cap the number of study permits issued for the next 2 years so that only 360,000 vocational and undergraduate students would be permitted to study in Canada from abroad. This represents a 35% decrease in the total number of vocational and undergraduate student study permits that were issued. In December of 2023, the IRCC also revised its guidelines to raise the financial requirements so that foreign students coming to Canada had to have from what was previously a $10,000 requirement to over $20,000, already in set finances and capital and assets prepared before they come to Canada, so that they could pay, in their words, so that they could pay for tuition and travel. But the effective outcome of both of these measures is to limit international students coming to Canada. Under immigration law, immigration officers can unilaterally, are actually not even unilaterally, they're mandated to deny study permits where they have reason to believe an international student does not have the necessary financial resources. Mark Miller described these measures as protective mechanisms for students, indicating that the bad actors are not students themselves. They are certain colleges described as the college equivalent of puppy mills that are churning out diplomas, which is fraud and abuse, and, quote, it needs to end, end quote. Nonetheless, taken as a whole, the policy decisions of Parliament and the nature of our public discourse combined seem to confirm the idea, especially to the Canadian public, that international students have to be limited in their numbers and entry into Canada, and that this will somehow benefit our housing market. It abstracts consideration of other actors, namely domestic ones, in this debate around the housing crisis. The debate shifts not to the question of zoning policies of municipalities. It shifts away from questioning development companies who often singularly focus on lucrative or luxury housing. We do not consider the role even of these puppy mill colleges that was named by Mark Miller as directly in this new system and policy that is being enacted by our federal government right now. Instead, the focus of our political conscience and our legal system has singularly pinpointed for scrutiny the international student. And so this is where I want to begin this talk and this discussion. I want to situate an understanding of where our law in Canada currently exists and what it means for the international student to navigate that, what it means for their rights, for their access to justice, to ensure that they are not unfairly imposed by unfairness or abuse. So this presentation is based on a paper I wrote as part of a directed research study. I intend on submitting it for publication, so I'm eager to hear your thoughts, criticisms, feedback, whatever you have to tell me about it. So I'm going to do this talk in namely 3 parts, and this follows the same structure as the paper. First, I want to discuss this conceptual model I have, borrowing from critical race theory of the established citizen. So this is a theory of how I discuss who is the intended beneficiary of our Canadian legal system. Second, I want to outline the particular vulnerabilities and insecurity that is created for international students in our immigration system. So here I'm going to particularly highlight the study permit, but I'm also going to talk about other matters of procedural injustice for international students and other non-citizens within our immigration system. Finally, I'm going to end by just discussing some of the social impacts that move from our immigration system into tenancy law. What does it mean for an international student who might be defined as temporary or potentially deportable in making contractual agreements with landlords? So let's start with the established citizen. The established citizen is a model I advance to discuss race, and especially the construction of race in law. Before I explain what this model is, I think it is necessary to describe what I mean when I discuss race, and also kind of give light to critical race theory, these various bodies of scholarship that informed this theory of mine. Race is a function of constructed hierarchies of imagined communities, to borrow from Benedict Anderson. The object of critical race theory is to provide a critical account of race as a social structure that is embedded, recreated, and reinforced by our legal institutions, and that facilitates conditions of advantage and disadvantage. A lot of people think of and discuss race in terms of biology or aesthetic characteristics, and while these things certainly play a role in how we come to construct race, it is also very important to recall that race is an unstable category. The same people can be racialized differently in different geographic, temporal, and social contexts. I myself, as a mixed race person, have felt the benefits of being racialized as white in certain social contexts and different settings, but I've also felt the stark contrast of being racialized as Arab in other contexts. So what does race have to do with citizenship, and what does it have to do with the international student? Tenzia Akiume has written a seminal piece called Racial Borders, where she discusses how immigration law and the modern state construction of borders creates exclusion, and so it is both informed by the construction of race, but borders themselves construct race. They help shape how we think of race. Think of the border itself as a site that is both informed by race and that informs race. We have set up a system where we can legally exclude certain people outside of our territory as non-members of the Canadian polity, our legal polity. Thus, pre-existing and independent constructions of race and belonging help construct and inform who is part of the us, who is part of the Canada. And also it helps construct who is welcome, who is already in the community. A lot of us might readily imagine, things like anti-Arab, anti-Black, Islamophobic surveillance that happens along the border. But the legal enforcement and logic of these exclusions also reinforce, perpetuate, and create legal exclusions and legal inclusions. For example, think of the role of our visa requirements, which are set under the Immigration and Refugee Protection Regulations. So certain nations and certain people from certain nationalities are visa exempt, namely ones who are described as coming from nations that have economic ties with Canada and that have an economic benefit to Canada. So these are nations like the United States, many Western European nations, Britain. So while discussed in racially neutral terms, the output of this is that our immigration law system treats certain people from certain nationalities as already kind of welcome in Canada, at least for the purposes of travel. Certain people can already come to Canada, are assumed to be welcome into the community compared to others, compared to those coming from African countries, from West Asian or South Asian countries that are presumed to that have their visa requirements. So even though British or American people are not Canadian citizens, or not strictly part of our legal polity, we have set up a system that presumptively assumes them welcome here. And so they can be imagined as belonging in Canada. So the established citizen is a theoretical model I advance as the abstract ideal of someone belonging in the legal polity, belonging in Canada, and is deserving of legal rights. It is premised off of Cheryl Harris's work, who is a seminal critical race theorist, and her writing, Whiteness as Property. I refer to the extracted established citizen in terms of citizenship because citizens can be considered the ultimate political and legal subject agents of democratic states. So who is the established citizen? This is not an actual person. This is an imagined person. And it is the person who is imagined to be the beneficiary of legal protections, of policy initiatives, of things that government want to have for the benefit of the community. It is this imaginary person who is supposed to exemplify the community itself. So by this, I don't just mean to refer to those exclusively with formal citizenship, nor even to those who may be racialized as white. The established citizen is someone who, as I said, is someone abstract. And so it is a concept that is flexible and not constant, just in the same way whiteness as a racial category, or any racial category, may not be constant and may shift, depending on different dynamics. So the established citizen speaks to the qualities that, under various different shifting circumstances, can grant someone greater proximity to belonging in Canada. This can include, for example, the ability to integrate into Canada, access to English or French language, economic establishment in Canada, the ability to work in Canada, all of which are concepts that actually underpin and are deemed necessary for economic immigration into Canada under our existing statutory regime. Under this light, the established citizen can include those who displayed the imagined characteristics of whiteness, being able to speak English, being able to speak French, and that renders them more cognizable as someone that could be established in the community, as someone who could be economically stable here, as someone who could be belonging. So an example case I just want to highlight about this is anti-blackness in the context of Montreal. And this is just to understand our existing legal infrastructure and the racial bias within it, and so that we can understand how we talk about it in a modern sense when we talk about international students. So in the late 1980s, the Rassemblement des Citoyens de Montréal had gained prominence as a local political party running a campaign that centered on the ideals of housing rights. They had a huge thing about tenancy rights and the protection of tenancy interests. In 1989, after being elected into local government, the RCM implemented its first major housing initiative in Montreal called the Programme d'acquisition de logements locatifs, or PAL. Under this initiative, the city would purchase rundown housing, renovate these residences, and then resell them to tenancy boards, to nonprofits for tenants, to the city housing authority, to cooperatives, to both create more affordable housing in those areas, and also what they said would stimulate a new sense of, quote, attachment for residents in these areas in their milieu. PAL particularly targeted neighborhoods with significant black presence, ones that policymakers and politicians would describe as ghettos. These included neighborhoods like Côte-des-Neiges, Notre-Dame-de-Grâce, and Cartierville. PAL initiatives also accompanied increased police surveillance and cooperation between the city, public housing authorities to evict tenants suspected of drug dealing or allowing drug dealings to happen in their units. And this, of course, had a very racialized impact of displacing numerous black tenants. The evictions were supported under Quebec law in Article 1618 of the Quebec Civil Code, which prohibited tenants from changing the form of rented property through illicit activities. And the evidentiary threshold for this was much lower than in a criminal setting. In law, we talk about beyond a reasonable doubt as a very high evidentiary threshold in criminal law. Here, it was merely a balance of probabilities. So you didn't need as much evidence if you were a landlord to evict a black tenant that you suspected of potentially allowing drug deals to be occurring in their unit. Law and policy here functioned to displace black tenants for the benefit of other Montreal renters, and the black tenant was not imagined to be part of the public, to be a part of the community that was to benefit from PAL. And so to understand this more, I want to just kind of put us into the socio-political context of 1970s Montreal, of 1970s Quebec, and how the black person was perceived. So in the 1970s, black people in Quebec were presumed not to be able to speak French, as many were Anglo-Caribbean in background. And over time, more waves of Haitian immigrants began to come in the 70s and 80s. But especially the later waves were defined as being economically working class, most likely to be working as domestic servants or in other service jobs. And many also came to Canada irregularly without status. And so the public perception of black people often was that they couldn't speak French, or if they did speak French, they were not legally authorized to be here, or they were otherwise economically not established here. It was a context where black people were imagined outside of the community, of the polity of Montreal. And so PAL represents a poignant and obvious example of how our law is meant to construct a clear intended beneficiary, those who got to enjoy the benefits of affordable housing. But in so doing, it requires constructing a non-beneficiary other, someone who is imagined outside or unbelonging to the community, those outside of the beneficiary class. The established citizen necessarily and systematically requires constructing a racialized, non-established citizen other, who is undeserving of those same rights to property, status, and recognition. And so with this as a model, I'm going to carry this through into the conversation about immigration law and tenancy law, the established citizen, to situate how these systems impact international students. So let's talk about study permits. Every foreign national in Canada, regardless of their nationality, is required to obtain a permit to engage in study in Canada, so long as that study is longer than 6 months in period. Some of you in this room may be well familiar with the requirements of obtaining a study permit because you had to do it yourself. But I will reiterate it for those of us who are unfamiliar. Under the Immigration and Refugee Protection Act, the specific requirements for a study permit include having a written acceptance letter from a designated learning institution, so it can't just be any college, it needs to be one that is recognized by the Canadian state. You need to have not previously engaged in any unauthorized work or study in Canada. Granted, there are ways to get around this, but largely speaking, you can't have engaged in unauthorized activity. You need to have sufficient financial resources, which is going to be a major point that I'm going to be talking about. And fourth, there is a continuous condition set on you that you need to remain enrolled at your institution, your designated learning institution, and that you need to actively pursue your program of study, which, yes, technically means that if you are a bad student, it is possible that you may be determined to not actively be pursuing your study and that your study permit may be revoked. So I really want to highlight this financial requirement first. It obviously has a sense of a classist dimension to it. And as set in the immigration regulations, it mandates that applicants have pre-existing available finances to pay for tuition. They have to have these finances, quote, without working in Canada. Now, there's a logic that the Canadian state, that policymakers had when doing this, because the idea was that international students are expected to be full-time students, and that's a condition, especially as I just said, they have to be actively pursuing their study. That's a condition for them to maintain their study permit to remain in Canada. And so if they're going to be full-time students, it's presumable that they would not have the free capacity to work long hours because of the time demands of their program. Nonetheless, even on top of this basic assumption, the regulations restrict working hours for international students, those situated in Canada under a study permit, to no more than 20 hours a week off campus during academic sessions. But even if there is an internal logic to this system, The immigration protection regulation system in place negates the possibility of an international student who is fully able to independently financially support themselves in Canada through work. It's not a system that measures your actual ability to be financially independent, to maintain your living in Canada, but one that instead asks about pre-existing capital. And so it sets an already a value standard of who should be able to come in and who should be excluded. This is also particularly evident in the lack of scrutiny of designated learning institutions. As Canada capped the number of international student permits, there seems to have been a lack of similar scrutiny of these institutions. A post-secondary institution can only be named a designated learning institution if it is directly administered by the federal government or through an agreement between the federal government and a province who designated it. BC and Ontario in particular have vowed to crack down on fraudulent institutions that have accredited designated learning institution status. But when we are looking right now at our current framework, the federal legal framework and guidelines only function to name the international student as the subject of administrative questioning and discretion. Administrative officials that are looking at students coming into Canada are only looking at them, their finances, their total numbers, irrespective of the genuineness of the institution to which they were accepted. In short, the federal legal infrastructure singles out international students, and they become the object of surveillance and scrutiny. So I'm going to kind of more directly situate the international student in reference to the established citizen. International students are actually relatively advantaged comparatively when judged against the established citizen. And this is not to say that they are accepted as part of the established citizenry, but rather that their educational experiences and oftentimes the high skills that they either come prior to arriving in Canada or that are assumed to have been acquired through the educational experience makes them cognizable in Canada, especially in terms of the free market. The idea of belonging in the established citizenry is often mapped out in an employment context, and I'm really going to highlight a lot of things about this idea of belonging do have direct capitalistic ties, that there's always this kind of idea of what you mean in terms of the benefit to the economic benefit to the community. Canadian employers prefer to hire those with familiar educational backgrounds and work experiences. And so often this is done to the exclusion of qualified candidates from the global south who lack domestic Canadian credentials. And this is directly reflected in our immigration system. One specific category of economic migration to Canada is called the Canadian Experience Class. And this is a direct category to apply for permanent residency in Canada that principally requires that you have had work experience in Canada. Now, the Canadian Experience Class does not apply educational experience as part of its relevant experience, but international students actually have ready access to this program because our immigration system allows them to apply after graduating for a postgraduate work permit. And this is a set-in thing. So international students can work for the necessary number of years in Canada with comparatively more relative ease than other non-citizens. So they can gain access to the Canadian Experience Class stream. I also want to talk about our comprehensive ranking system, which many of you might be familiar as like Canada's points system for economic immigration. So this is a system where they look at pre-applications and they select based off of a number of deemed points who should be formally invited to actually apply for permanent residency in Canada. And those with the highest points in a given cycle will be invited to formally apply. And you can only apply if given a formal invitation. So 30 points in this system are rewarded for Canadian educational experience, with the necessary number of points in a given cycle usually sitting around 450. I think it's also important to talk about economic lucrativity and the association of international students and economic benefit. So 2014 reports from the Department of Foreign Affairs and International Trade affirmed that international students contributed to a $4.2 billion gross domestic product to Canada. And it was that same year that the federal government announced a strategy to recruit more international students as part of our economic policy. So immigration law here thus facilitated the international student as an imagined consumer for the benefit of the Canadian economy. And this is actually very interesting when we now think about it in contrast now to the housing crisis debate, because there the international student is framed as an unwanted consumer. The irony being, this is where we have to begin to situate the international students as being someone who is outside the established citizenry. Because for whatever value that international students bring that have as potentially belonging, our law still sees them as foreigners outside of the Canadian community. And it should be highlighted that any benefit of having had Canadian educational experience is only realized at the point of graduation. It is only then that you have that cognizable experience for the market, that cognizable thing that makes you economically valuable as part of the community. But during the period of study in which an international student is here, their formal status is someone who is a foreign national who likely does not have any immediate in like the here and now, route to permanent residency. It's only a potential future route. And this is important when we talk about our case law, because the foreign national is someone who has distinct non-access to procedural rights. In the seminal case Chiarelli, Justice Sopinka of the Supreme Court of Canada described non-citizens as having no right to stay or enter in Canada. And he described this in a way that talked about it in contractual terms. He said that any breach of the requisite conditions in immigration law, quote, is a deliberate violation of an essential condition under which the foreign national is permitted to remain in Canada, end quote. Sopinka then reimagined the foreign national as being a contracting party, even though our law doesn't recognize this as a contract. But the international student or other foreign national who's entering into Canada is now divorced from their other relations with people. It is one that is imagined uniquely with them and the Canadian states. They're not imagined as part of the community, as having relations with people in Canada, as having a livelihood here. No, the right to remain or enter in Canada is now proposed merely as a privilege granted by the state, and one that is granted in equal exchange for the consideration of behaving in a way that does not disrupt the Canadian polity. The damage of breaking this social contract stands irrespective of the actual gravity of a foreign national's conduct. So whatever you do that may breach this contract, irrespective of how bad it actually is equal in disrupting this social contract. So I'm going to quickly talk about administrative vulnerability. This can take a while. Administrative law is very complex, so I'm going to rush through this part because I want to make sure we have enough time for questions and everything. Basically, when we talk about immigration law, everything in immigration law is essentially made by administrative decision makers, and that just means representatives of government who are not legislators. So this includes immigration visa officers, border officers, members of the Immigration Refugee Board, which is the immigration tribunal in Canada. These are people who make the decisions like, am I going to validate your study permit? Am I going to revoke your study permit? Am I going to allow you into Canada? So all of these decisions are administrative decisions. And there's two principal thing that we talk about especially in law school when we talk about administrative law. One is the question of procedural rights. So that's, in the context of these decisions, this means things like your right to make a submission to that decision maker, like to say, this is my stance on this and I think you should put this into consideration. It includes things like your right to counsel. It includes things like your right to an unbiased decision maker. A lot of those things that matter for the procedure of how a decision is going to be made. The other thing that matters here is what we call judicial review. So if a decision is made and it's unfair or unreasonable by an administrative decision maker, judicial review refers to the process of putting it before the courts and having judges look at this and ask, was this unfair, was this unreasonable, and can we reverse this decision or do something about this decision? So remember when I said that non-citizens don't have a right to stay in Canada, international students don't have a right to stay in Canada? That really impacts their procedural rights because our courts have interpreted that to mean that while there might be minimal procedural protections when it comes to these various decisions, like is your study permit still valid? Did you maintain these conditions? Those are lower procedural rights because you don't actually have a right to be in Canada. It's only a mere privilege. And so this can actually, and in the case Cha v. Canada, this was determined that in the context of an inadmissibility hearing, Cha did not actually have the it wasn't a hearing, it was an inadmissibility interview. He did not have the right to legal counsel. So these very practical and serious things for how you navigate this immigration system and how you go before all these decision makers, making very profound decisions about your right to be here, this all impacts that. The other problem in our system arises in judicial review. And this one I could go on for a very long time. The standard that is set right now is often most decisions are judged under reasonableness. Just to quickly summarize, what does reasonableness as a standard mean? It means that judges are most likely going to give deference to whatever the decision of an administrator that was made. They just need to show that there was some kind of logic to what they were saying. It needs to be within a range of reasonable options. So the administrative decision maker doesn't actually have to make the best decision, the most logical decision. They just need to have any kind of line of reasoning that you can follow that makes sense. Even if the judge personally disagrees with it, that decision can be upheld. And within this, there's a huge problem in that a part of reasonableness under the seminal case Vavilov asks decision makers that courts look at decision makers and recognize their expertise when it comes to making these decisions. That these are people who, are more of an expert body than judges in courts when it comes to these particular matters of immigration. The problem is how they describe expertise and where it comes from and how you measure it. So courts can look at the reasons given by an administrator for whether they have demonstrated expertise, but also if the administrator has given no reasons, the case Vavilov says that can be an indication of expertise. In other words, if you take out this question of reasoning and reasons, the expertise of administrative decision makers can be explained by their expertise. A very circular reasoning. Further, Vavilov explains that that reasons that are offered can be used as a way to analyze whether there is actually a logic, whether there is actually an unreasonableness to this decision. But remember when I was talking about procedural rights earlier? Part of procedural rights is actually the giving of reasons. So to be offered reasons for a decision is a procedural right. And because international students have low procedural rights, they often are not actually given reasons for whatever the decision that was made. So that means that the courts actually don't often have a formal document of formal reasons to actually judge if a decision was actually unreasonable. The only way to access this would be through making what we call an access to information request, which takes months. And this can be just for written documentation of some of the thoughts or reasons that an officer may have had. But if it's something takes months and you have a revoked study permit now, that's going to impact you now. And the point of having those reasons months from now is going to now be moot. I also think it's fair to point out that a lot of immigration advocates have criticized members of the Immigration Refugee Board and other immigration officials for actually not being required to have any prior qualifications or past experience working with immigrants, in law, with refugees, none of that. You don't need prior experience. And yet, our legal system has presumed them as inherent experts under administrative law. And that language of inherent expertise was actually used in the case Edmonton East. So now I'm going to shift to talking about housing. So many international students may find housing accommodation that actually falls outside of the legal protections for tenancy. For example, in Ontario, rooming houses, which is a situation where a tenant shares a washroom or kitchen with the landlord, is fairly affordable and common accommodation for many students. But this kind of accommodation is explicitly outlined in the Ontario Residential Tenancies Act as something to which tenancy protections and regulations do not apply. Similarly, in BC, and this is unique to BC at least by comparison to Ontario, student housing made available by universities or other educational institutions are not covered under the BC Residential Tenancy Act. So Green College, for example, is not covered under the same tenancy regulations as other leasehold agreements. Now, that doesn't mean that there's no legal protections in terms of the tenant's rights for students living in these kinds of accommodations. There is the privity of contracts, so those contractual agreements that you may remember of signing with Green College, with the University of British Columbia, that offers certain protections. There's what we call privity of estate, which basically means like you're living here and the landlord owns it, so there's like certain kind of rights that give you right by kind of living here. But I mean, by comparison to other housing accommodations, students do not have access, especially international students do not always have access by nature of that accommodation to the same kind of legal protections. I also think it's important to acknowledge that landlords, generally speaking, not even just with international students, have an imbalance of power over tenants. One of the obvious ways in which this plays out is that they have financial capital over tenants. The other is that when we're looking at the situation, like the positionality of a landlord versus a tenant, the interests of the landlord are most often just monetary in nature, whereas those of the tenant often concern the most fundamental and basic right of shelter. The landlord has been written, though, and has been described and imagined, and this has been discussed in the scholarship of Sarah Buehler, as someone who is a good citizen, and this is by nature of their home ownership. Home ownership is often seen and imagined and discussed in law, in social life, as a marker of someone who is productive, trustworthy, a stable community member, someone who is part of the neighborhood, someone who is part of the community. I mean, look at the fact of how home ownership was a basic right for the right to vote across the US and Canada. The landlord then, by virtue of home ownership in title, is often imagined as being easily within the established citizenry, both socially and legally, but only merely by their status as a landlord. So your interests are valid. So our legal system and our social system says the landlord interests are valid and ought to be protected as though they were as fundamental as shelter itself. And I mean that quite literally, because across provinces, the statutory regimes that regulate tenancy law describe it as something where they're balancing two sides, the interests of tenants and landlords, something that are equal as presented in these statutory regimes in terms of the balance of interests. But now I think it's important to really situate the international student, especially by comparison to the established citizen, when we talk about this imbalance of power with landlords. So international students are seminally defined by having liminal status, by having a status where they're allowed to be here, but it's temporary. It could be easily revoked. It's a precarious status. And that shapes social relationships, contractual relationships, and social conduct. I'm sure many of you have met such persons, whether it is a foreign worker or a foreign student, who may fear stepping out of line while in Canada out of a concern that that conduct may impact their right to remain or stay here. And so compared to other tenants, international students must contend with that precarious status, marking them as removable, as potentially deportable, when negotiating, entering, and maintaining a tenancy agreement with a landlord, or really any legal or social relationship. The construction of temporary authorizations is liminal legality. We're creating a situation where international students, while simultaneously having a right to be in Canada right now, are also legally constructed as having one foot out the door. As stipulated in the terms for both maintaining a temporary resident visa and the study permit, international students are expected and required to leave after the authorized period of stay, unless they find other authorization. So the international student is marked as temporary in a legal social setting, and that justifies social exclusion ab initio. Presumed temporariness can contribute to discrimination in the rental housing market. Indeed, it reinforces the idea that someone is not from here and asserts a social concept that they are supposed to be returned elsewhere. And so this can impact different things. It can impact the legal standing of international students and being marked as a less than trustworthy outsider when trying to enter the rental market. In a qualitative study of housing markets in Newfoundland, one tenant had quoted an experience where a landlord asked them, "You're new here, but you're going back after a year, so how can I trust that you'll pay rent every month?" So the status of temporariness marks a social understanding of untrustworthiness. Yet we must also recall that because home ownership, as I mentioned earlier, is associated with good, responsible citizenship, or a marker of being within the established citizenry, landlords benefit further from by being compared to the temporariness, to the liminalness, to the deportability of international students. So imagine this in the setting of a tenancy tribunal where a tenant is contesting an eviction. What happens when this established citizen landlord is compared directly in a tribunal setting when their statements, usually what is the only thing that's offered as evidence, the testimony of both the landlord and the tenant, is being compared to someone who is seen as not from here, who is to return elsewhere, who does not have interests here, who is not permanent here, someone who is going to return elsewhere. There is an innate racial capacity for racial bias against the international student by comparison to a landlord who is marked by permanence with homeownership, with membership in the community when entering into these tribunal settings. I also want to just acknowledge that it's not only the status that comes from immigration law that impacts tenancy law for international students, but the reverse can also be true. So if you are evicted, that carries large financial constraints on someone. That is a large financial burden. And so that can potentially upend your financial requirement, which you're intended to maintain the financial requirement in order to maintain your study permit and right to stay in Canada. So these various systems intersect and create various ways in which one may encounter injustice as an international student. And so just to end, I want to talk about a couple case examples from a couple tribunal decisions that I studied as part of my research. So the first is from the Office of Residential Tenancies in Saskatchewan. And in this case, a landlord was having a dispute with I believe it was 2 international student tenants over the number of pets that they had. He claimed that they had more pets than they had initially stated that they would be bringing in. And so in a dispute with them, he threatened to call the police, as well as making other if you read the full thing, kind of abusive statements against them. And of course, the threat of being called to the police caused great anxiety for the tenants, who now fear that they could be deported. Similarly, in a 2016 case before the Ontario Landlord and Tenancy Board, a landlord responded to 2 international students who were complaining to the landlord that the unit that they were occupying had a mice infestation and that the front door lock was broken and not working. And so in response to that, the landlord told them that he had reported bad tenants in the past to immigration authorities and to the educational institutions that they were studying in for running away from their lease. So the status of being deportable in a strict sense doesn't actually enter leasehold agreements. It doesn't actually enter the contract or the privity of a state. But there is this lingering threat of deportation that facilitates both abuse of power by landlords and presents opportunities for exploitation of vulnerable international students. So in these 2 contexts, it's actually unclear whether at any point these international students' tenants were actually in a position where they could be made removable. In order to actually be found inadmissible, to be removable in Canada, a foreign national would have to be convicted of a very serious indictable offense or 2 distinct summary convictions, which are lesser offenses. And it is doubtful that a police encounter over a tenancy pet dispute would actually arise to that kind of level. So there's also no ground for removing someone, for a foreign national, for merely exiting a lease. But this threat speaks a lot for itself, the fact that these landlords felt themselves to be in a position where they can levy these kinds of threats to student tenants. It results in anxiety and vulnerability of these students, and it should be also noted that amongst the psychological stronghold that landlords may now present themselves over these tenants, it actually is possible for a landlord-tenant dispute to result in a foreign national becoming inadmissible. A landlord could make a report to the Immigration Refugee Board that a tenant is failing to comply with the conditions of their study permit. A landlord could, in confrontation with a tenant, lead to a kind of dispute that results in a potential conviction or arrest. So ultimately, like in these two cases, the landlords asserted their power over them, invoking the racial power of being established citizens and invoking the racial power of them being non-belonging, temporary, deportable. The tribunals in both cases found that the nature of the threats made by these landlords was a breach of their legal duties. But just because there are legal duties imposed on these landlords doesn't negate that reality of abuse of power that I talked about that stems from the legal but blends into the social. And so I think I'm going to end there with just kind of acknowledging that our law and our society, our social relations are deeply intertwined. And, immigration law does not exist in a vacuum. And so the status and the social precarity that stems from immigration law has impacts in matters like tenancy. And with that, I'll open for questions.